do not round an employee's time. That means that if an employee clocks in at 6:02, you don't put on their pay stub, they're in at 6 or 6:05. They're in at 6:02, and you pay them from 6:02. The California legislature had been talking about making revisions to this for the last 3 years, and instead they just waited for the courts to do this. And what ended up happening is in the Woodworth case, the California Court of Appeals came back and said, yeah, you know, technology is really good right now, and employers should be able to pay minute to minute. There's no rational reason that they can't pay for every minute that an employee is working. And as we know from the Troester versus Starbucks case from about 4 years ago, we also know that, you know, if an employee is done working and they clock out and then they do something else, we're supposed to compensate them for that, because that's work off the clock, and employees should not be allowed to perform labor off the clock. And so now it's our obligation to make sure that we have true and accurate records of the actual time that the person was performing labor. And guess what, guys? I'm going to break some news to you right now. Employees lie. They lie all the time. And they will say, oh, I worked off the clock for about 15 minutes every single day. Really? Where? Where were you? And why would you clock out and then continue working? Who asked you to do that? Were you told that you had to do that? No one would do this voluntarily. So, you know, there are things that we get to play with in deposition, but at the end of the day, these are the types of things that if you have good documentation, you aren't, you know, changing the time that an employee is actually punching in and punching out and then taking their meal periods, and you're actually paying them minute to minute, we've got great ammunition to fight back on these cases. And I wish more of my clients followed this procedure, because then we would be able to take a stronger position, as opposed to when a lawsuit comes in, we take a look at the documentation, we kind of shake our heads and go, crap, we got problems, guys. And we have to move directly into, you know, damage control mode. We try to settle these cases as quickly as we can when there's liability, because otherwise it's just going to end up costing the employer more money to fight the battle that they can't win.